Okay, we are live committee in Economic Development, Housing, and General Affairs. It is June 20th, veto session, and we are looking at S103 because we looked at an informal version or a kind of not yet passed version, and the House passed the bill. Essentially, we didn't get it messaged until after we were done meeting on the final day of the regular session. So we want to make sure we understand the full extent of any changes before taking a vote. And Senator Brock had looked up our witness list just to remind us who we heard from.
We heard from Carrie Brown, Executive Director, Vermont Commission on Women, Richard Cassidy, an attorney, Austin Davis from the Lake Champlain Chamber, Damien, our alleged counsel, Sarah Robinson, Deputy Director, Vermont Network Against Domestic and Sexual Violence, Megan Sullivan from the Vermont Chamber, Julio Thompson, Director of Civil Rights Unit at the AG's office, and Boer Yang, Vermont Human Rights Commission. So those were our witnesses.
Okay, and I have reached out to the administration to see if they want to be heard today on this issue, and they are checking, recognizing we didn't necessarily intend to meet. It's all short notice. We're just trying to make sure that we don't go to the floor without understanding exactly what has changed and where we all stand. With that, we have Damien in the witness chair, and we're grateful to Andrea for helping us today's stream. So thank you, Damien.
Great. Good morning. Nice to see everyone again. For the record, I'm Damien Leonard from Legislative Council. So I'm happy to answer questions about the bill. For purposes of my walkthrough, I'm just going to identify where the House has made changes. But if you have any questions, please feel free to stop me or just ask me when I'm finished.
They did enough changes to make it a strikeout. So
they made it a strikeout for purposes of people being able to see the full bill in the calendar rather than having to try to cross-reference things.
I support that notion.
So
that's a great idea.
The changes are actually fairly small. The first changes will come in subdivision A7 of section 1, and that's the equal pay provision. The Senate passed it. The Senate passed version added to the existing law race, national origin, and qualified individuals with a disability. Currently, the equal pay law is just based on sex. You can't pay different wages based on sex. Senate version would have expanded that to sex, race, national origin, and disability. The House version adds sexual orientation and gender identity to that list.
And what I recall is that Julio in the AG's office said that he, in his opinion, that many of the courts were already interpreting sex at the federal level to include gender identity and sexual orientation. So he didn't think it would be a huge change, but would spell it out.
So the Vermont law spelled out that discrimination is prohibited on the basis of sexual orientation and gender identity. Federal law has never spelled that out explicitly in the law, so the courts have held that sex includes sexual orientation and gender identity. So that change does make us consistent with the federal interpretation of the term sex. Whereas if we had left that out, it would raise the question of, did Vermont mean to intentionally leave these out? So
that's in section 7.
Yep, that's subdivision 7 and section 1.
Section 1.
And that's the same. Looking in the little Romanet subdivision A4 under that, it's the same change, adding sexual orientation and gender identity to the list of protected categories. In subdivision 7C, so a page later, and my line numbering is off from yours because I'm showing a track changes.
Right.
We're just in the calendar, so we're
and we'll just keep it general and not refer to any specific.
All right.
That's on the same page.
Perfect. So in 7C, Senator Harrison here actually has highlighted it perfectly on her copy of the calendar.
Maybe you should.
The Romanet 1 is new language added by the House, which basically says nothing in this subdivision shall be construed to create any new rights for an employer to inquire about a characteristic of an employee that is otherwise unknown to the employer, upon which pay discrimination is prohibited pursuant to the provisions of this subdivision. I apologize for the clunky language, but basically what this is saying is we're not giving you rights that you don't have under like HIPAA, for example, or the Americans with Disabilities Act. So you're restricted under HIPAA and the ADA about asking about an employee's health conditions. And there are certain ways you can ask and certain ways you can't ask. So as an employer, I can't say, tell me about your disabilities. But if you bring up a disability with me, I can say, what accommodation do you need to do your job if you identify the disability as making it difficult to do your job?
Yeah, and in
Well,
your,
let's take a hypothetical, if I could. You have an employee who is supposed to be working on a particular machine and they're just not able to do it. And as a result, you either pay them a lesser rate than you pay other people doing the job because they aren't doing the job as well, but you have no knowledge that there's any disability or other issue involved. Now, at that point, where are you?
So the ADA protections are triggered when you have knowledge of the disability. The equal pay provisions under both state and federal law permit an employer to pay an employee less if the employee is entitled to less based on a bona fide seniority system, merit, or lesser production. So if you're, for example, if employees get raises based on their ability to meet or exceed certain production quantities and an employee doesn't meet that, you can pay them less, provided it doesn't perpetuate some form of discrimination.
Now, that is much clearer in a machine type situation where you're reducing quantities. It could be subjective in an administrative capacity that, gee, I just don't think your work is as good as the other person's work. Now, if that person has not asserted or made the employer known that there's some disability, at the point at which they discover they're getting paid less or they're about to be disciplined or whatever, and then bring up the fact that, well, I have this disability. At that point, as I understand it, the employer can inquire about the disability?
The employer can, at that point, yes, there can be inquiries about whether there's a reasonable accommodation that would enable the employee to do their job. And then that's a case-by-case discussion, because obviously disabilities and the needs related to them vary, and also the needs of the job vary. And also, depending on the employer, what is a reasonable accommodation may vary. So for example, if a reasonable accommodation is a flexible work schedule to allow the employee to receive treatment, that's something that most employers probably can accommodate. If the reasonable accommodation requires physical alterations to the building, that's something where the employer will have to take into account how much that would cost versus their ability to pay for those alterations and so forth. So, but at that point, the employer is allowed to say, well, you've identified this disability, what sort of accommodation do you need? And if the employer can't provide that accommodation, the employer has the ability to come back and say, that's not reasonable because it would cost us too much, or it would alter the nature of your position so you're not performing the essential functions of your position. How about this accommodation instead? And then it becomes a dialogue between the employer and the employee. And if there is no way for the employee to perform the essential functions of their job with or without a reasonable accommodation, at that point, the employer can terminate the employee or can transfer the employee to a different position.
I'm just trying to, to understand from a few practical situations, the limitations, if any, that might be placed on an employer acting in good faith. In the example that I used about the machine, using a particular machine in production, if an employee, the employer notices that the employee is not raising his left hand above his shoulder in the work, which seems unusual for doing that particular job efficiently, Can the employer ask, do you have a problem with your left arm?
So the employer is able to ask questions. So for example, the employer could do different things. They can talk about, in order to operate this, more efficiently, you need to do a two-hand motion or something like that. At which point the employee would have the opportunity to say, well, I can't raise my left arm above my shoulder or something like that. The employer, if they notice a change in behavior too, can also say, are you okay today? I notice you're not raising your left arm. I'm concerned that you might not be able to operate the machine efficiently. Do you want to take a sick day to recover? Do you need to see a doctor?
And that's already kind of existing best practice around
Right.
ADA.
So there's this balancing of workplace safety. If the employer sees a situation that threatens workplace safety, they have the ability to ask questions and take action to address it. The important thing is that employers can't say right off the bat, tell me all your disabilities, that they, you're not allowed to make assumptions about an employee based on a disability. If the employee is not functioning at the same level as their coworkers in terms of output or production, then you can work with the employee like you would with any other employee to try to remedy the situation, whether it's additional training.
I'm just trying to say where the guy,
Yeah.
for the average, the employer is not necessarily skilled in equal protection law.
Yeah.
How, are the guidelines sufficiently clear that a reasonable employer, particularly at the product level, at the level dealing with an employee on a job, is not going to fall into a trap of non-compliance. For example, is it appropriate where you have job qualifications such as has to be able to have full motion of both arms, has to be able to lift 50 pounds or more? Presumably you can ask, can you do all of those things?
Yes.
But you
So
can't say, do you have any problem that would prevent you from doing any of those things?
Right, so you can say, can you perform the essential functions of this job, or can you lift, this job requires a great deal of lifting, can you do that? This job requires, the ability to operate heavy machinery for 8 hours. You can talk about this job requires you to be on your feet for 8 hours. These are things where you can identify those in the interview and ask questions about them. So the law's been around for more than 30 years at this point, and there's a wealth of information available through the EEOC, including questions and answers on all sorts of topics. It is not the most modern web page, but everything is hyperlinked, so you can jump to those things. And then there's another group affiliated with the EEOC that provides information on how to formulate accommodations in plain language for employers, so that they provide examples, suggestions, the kind of questions you can ask, and examples of how to navigate that. And that's called, I believe, the Disability Accommodation Network. And the EEOC provides links to that as well. But any employer can ask the question, can you perform the essential functions of this job? And any employer can address workplace safety issues, and they are still able, under the law, to manage for performance. So they're able to say, you're not performing adequately. And then if the employee does say, well, I have this condition, at that point, the employer can take steps, but they're not going to be penalized for having withheld a raise for an employee who needed an accommodation and didn't tell the employer they needed the accommodation. Because as an employer, you can't act in good faith to provide an accommodation if you didn't know one was needed in the first place. So it does get complicated, but this isn't changing anything that hasn't been the case for the last 30 years.
Well, that, of
So-
course, immediately ask the question, why are we doing this then?
So this is being put in here to make clear that we're not changing. That's all this language here is doing. So the equal pay protections, that would be an explicit difference. But the equal pay protections already have exceptions for merit, productivity, seniority, and other bona fide business reasons. So an example of that I think Julio Thompson shared was an instance where there was a workforce shortage. And so the employer provided signing bonuses to new employees, which meant that they were getting paid more. It also happened in the case that the AG's office got that, or that they were asked to opine on, or I forget his scenario, but where there was a difference in sex between the individuals who were newly hired and had gotten signing bonuses and the individuals who were currently on staff, which is why it came to their attention. And they said, no, that's a bona fide business reason. You had these existing vacancies, you couldn't find staff, and so you upped the ante with the signing bonus so that you could fill the positions and meet the needs of your business. That's a bona fide reason.
And Julio's logging on.
Yeah, I
Okay.
tried to send an email.
Thank you.
Yeah.
Yeah.
Just texted me.
Oh, perfect.
So-
Yeah.
The other issue that I had concerns about in the bill was the effect of this change that harassment discrimination may not be severe or pervasive.
And
I
that is
know we talked about that.
Yeah.
So
and that, as we talked about when the bill was first in the Senate, that's a significant change from
It is a
existing law.
So
So
as
that-
we finish walking through, remind us where that is.
So that.
Because we're just in C, Romanet.
Yep.
top of page 3349.
So it's the next bit, because there's some other new language that they've added.
Right, so let me turn back to the walkthrough here. So, Romanet 1 says does not create any new rights for an employer to inquire. The employer has the same rights they've had under existing law. And then Romanet 2 says it does not diminish an employee's right to privacy under any other law or pursuant to a contract or collective bargaining agreement. The House deleted the words regarding a disability or physical or mental condition because they were adding sexual orientation or gender identity. Their concern was, we just want to make this broad that employees have the same right to privacy that they would have under existing law. And so the right not to tell your employer about your sexual orientation or gender identity or something like that. And so that was the only House change there. There is in J, there's a small change which was identified first by an employer side attorney from Paul Frank and Collins. I can't remember if it was Karen Stackpole or another attorney from Paul Frank and Collins, but they identified, I think it was Karen, identified that for the comparatives language, if you're alleging disparate impact discrimination, meaning that it's a neutral policy, but it impacts members of one group differently than another, you need to show another employee, because otherwise you can't have that. So they raised that, and the Attorney General's office came in from the other perspective and said, we agree completely. That was an oversight in the language they had suggested in the Senate. And so the House added that, or disparate impact, as a cleanup.
Or disparate impact.
Yep. So that's in J.
And we have Julio joining us. So I just want to welcome him into the conversation about this one.
I would just like to understand what that means in practice regarding disparate impact discrimination when there's no other employee to compare it to. How do you know that there's a disparate impact?
So what this says that except when you're alleging pay discrimination or disparate impact discrimination, you don't have to provide that comparator. So basically for disparate impact and pay discrimination, you do have to provide a comparator. Yeah, so it's written as a sort of exception rather than to the rule that you don't have to show a comparator.
And is that the last piece of the differences?
I am just double checking. I think that is the last piece of the differences. The Senator Brock had asked where it says need not be severe or pervasive, and that's in K1 below that, and then in the definitions of harassment and sexual harassment in the next section, and then for public accommodations law, that's where the need not be severe or pervasive language is.
Thank you, Damien. Julio, thank you for joining on short notice. Damien just did a great job walking through the changes that the House made, and just reference some of the, places where the AG's office weighed in. I will see if we have any more questions either about the language or what's behind it, and see if Julio wants to just say a few words. Senator Brock, did you have any questions you felt like you?
I do. As I look at K2, behavior that a reasonable employee with the same protected characteristics would consider to be a petty slight or trivial inconvenience shall not constitute unlawful harassment or discrimination. How do you determine that?
That could be an off-color joke at a company picnic that's said once and the person works for years. That phrase, petty slights of convenience, is actually drawn from the case law in the Second Circuit that we belong to. So really, this bill is just codifying the law that we apply now. It's determined case by case because it depends on the nature of the remark, when it's said, who says it. The idea and the case laws where that come from is a recognition by the courts that you can't regulate all boorish behavior in the workplace, that courts can't go so far as to be a de facto HR department. And so that's where that language about petty slights and conveniences, sometimes people say things that are offensive to somebody they didn't mean to create an intimidating work environment. So it's just saying that, there's a certain amount of workplace frictions that arise from any number of reasons, where people just think someone would think a joke was funny or a movie that they saw was funny. So that's kind of where that comes from. It's not really a change in the law. It's there are several provisions in this law, and I think previously I provided kind of a chart matching up some of the language here with the case law, and this is one of those examples.
I just wondered if you, in effect, almost create a potential, in a contested case of a battle of experts. You bring in 5 people in this protected class, and the other side brings up 5 people who view the issue differently. Does that happen?
Not really. Not when you're talking about just like a very minimal sort of thing. Usually, if you have something where it's like a stray remark or 1 or 2 remarks that's made over the course of a couple of years, and those get pled in the complaint, usually those are handled by the court itself in a motion to dismiss, saying we'll accept your allegations as true. These 2 things happened to you. Those fall within this kind of buffer zone of petty slights and annoyances, workplace frictions. It doesn't really create an inference that you're being denied equal employment because of these remarks. And it's based on other cases and that have been decided before. It's rarely, and frankly, from a practical standpoint, when they come into our office and they tell us, these 2 things happened, we will say, and we would continue to say under this bill, if it's enacted, we would say that that's not enough, that's in the realm of kind of, you encountered boorish behavior. That's something that happens. It doesn't show that you're being denied equal access to employment. So usually it's handled at the very early stage, either by us or by the courts. And you never get to the point where the parties have to go to the expense of doing discovery, let alone hiring experts.
The severe and pervasive, I know, is something that we discussed earlier in terms of how does that use of severe, need not be severe or pervasive. How common is that in other jurisdictions?
Well, I mean, it really comes, it is very common in other jurisdictions that have applied. That's the standard that the US Supreme Court came up in. That was the phrase they used in 1986 in a Title VII case. Title VII applies to all 50 states with employers of more than 15 employees. And the court was trying to figure out, like, how bad does it have to be before someone would have a remedy in court? But increasingly, I mean, the country is kind of peeling away from that standard. New York City in 2005 rejected that standard, replaced it with something that's closer to what's in 103 here. New York State changed it in 2019. California changed it in 2021. Last year, DC and Maryland got rid of severe and pervasive. And part of the rationale that people have been moving away from it, and it really comes from the New York City case law that's been interpreting it for a decade plus, is that there are other types of employment discrimination that are clearly unlawful, that aren't harassing, that don't have to be severe or pervasive in order to be unlawful. In the other committee, I gave an example of cases from the 70s, for example, dealing with a multiracial workforce where they paid employees all the same. They all got the same company car, but they had job segregation. So black salespersons went to black-owned businesses, white salespersons went to white-owned businesses. And a black employee went to the EEOC and said, I want to be able to expand my business contacts and expand my portfolio that'll help me progress as a salesperson. And the employer said, no, we think it's better that, you kind of stick to your existing clientele. We think that's just better for, those owners of businesses, et cetera. Came up with some reason like that. Not something that would have to be shown to be a severe decision or pervasive. It was just some individual job opportunity that was missed, but it was clearly unlawful. And there are any number of other cases where employees get some inferior assignment, could be access to technology, where they have the bare minimum to do their job, but maybe someone of a different gender or race, or in some cases age, gets better technology for, based on some stereotyped assumption. You don't get the best laptop because we think men work longer hours and they should have the best laptop. You get an okay laptop, you can still do your job. Wouldn't be considered severe, depending on how often the person needed a laptop, not necessarily pervasive, but would clearly be illegal. And New York City, again, going back to the mid-2000s, they recognized that it was kind of anomalous that the only type of discrimination that had to be severe or pervasive based on the case law was harassment. And the court and the New York City Council changed their law to break away from that standard, and say, yeah, we just don't like the way people have to accumulate a really significant amount of abuse to have a legal remedy. Whereas if they are just denied, someone of a different race or gender is given preference in vacation scheduling, that's illegal. That's unequal treatment. So what's the difference? And that was kind of the rationale that has been, I think, gaining footage in some of our different parts of the country. Now it's on both coasts.
Thank you.
Well, I'm glad we're reminded of various subject matter in the bill. That's helpful as we move toward a vote. I personally don't want to keep this past noon. I want to make sure people have time to eat.
I'm fine.
So what I understand is that if we took some time with this, or, Senator Brock, if you were able to check in with the governor's office and there weren't any additional concerns, we could take it up at 1 o'clock today with a rule suspension. If not, we would take it up tomorrow. And, if people have further concerns about what happened in the House, I understand. If you do have those concerns and want to talk about them now, or at least let them be known now, great. Or otherwise, I don't know that we need to take a vote. I just want to see if we've addressed these concerns and then you can talk to
Yeah,
your
I'm
governors.
gonna have a conversation with the administration
Yeah.
about it for an hour, and get their input. too.
Okay,
So maybe we could, quickly huddle at 1 before we go.
so like,
I mean, it's obviously, we're gonna be here tomorrow, so the notion of, rule suspension isn't necessary, since it's on notice tomorrow anyway.
So just one less thing to do. Yeah,
To do it today, do it tomorrow, the easiest thing is do it tomorrow, and that way we're not rushed.
okay, so we'll anticipate doing it tomorrow. I do think
because we do
tomorrow's
need to
like,
take a vote to concur probably.
okay, so
I
we
think we
should take a vote. Do you want to wait and take a
Yeah.
vote?
Okay.
Okay, so let's let Senator Brock have the conversation. So we will plan on taking it up tomorrow.
So why don't we plan on meeting here maybe at 9:30? Are we aiming to go on the floor at 10
It's
tomorrow?
It's 10 every day.
10 every day. So, what a luxury. So how about if we meet here at 9?
9:45 is fine, this shouldn't be. taking-
Yeah, if I bring here at 9:45 is great.
Yeah.
Yeah, 9:45, okay,
Okay,
great.
great, yeah.
That
Sorry,
works better
no,
for
no,
me
it's okay.
too. I can't drop off morning, so.
Yeah,
Does that work?
Yeah, I can make it here from like 9:20.
So
9:45.
9:45 is okay?
Yeah.
Perfect.
um,
Camp drop off, what a joy.
Julio, if you want to join us again at 9:45 tomorrow, great, just in case anything last minute comes up. Senator Brock, if someone from the administration wants to talk, just let me know so that maybe we give it a little more time and I'll let people know by email, but otherwise, plan to be here at 9:45 tomorrow and we'll try to get it down.
Whatever we do,
We
we'll talk
can,
fast.
thank you.
What?
We'll talk fast.
Right, yes, that'd be nice, especially for her with crying baby problem.
No, she'll be thrilled to be back at the State House.
Yes, she will, this is where she's.
Thank
most
you,
of the time.
Andrea, for bringing us on. This was great.
Okay, thanks, everyone.